I've been the fly on the wall for more than 2 decades of sectional title disputes. I've got the data, the rules, and the real-world solutions. You're watching at Scheme Savvy, sectional title simplified. When you live in a South African townhouse or apartment complex, you are bound by a legal framework called the Prescribed Conduct Rules, or PCRs. They exist to prevent community chaos, preserve peace, and protect your property value. But many owners, and even trustees, don't realize exactly what the default law dictates, or how far a scheme can legally go when trying to rewrite them. Out there in the real world, hundreds of complexes are completely mismanaging their rulebooks, issuing fines under rules that are completely toothless in the eyes of South African law. Let's establish the absolute legal baseline. The current framework for all sectional title schemes is governed by the Sectional Title Schemes Management Act of 2011, which came into full effect on October 7, 2016. Annexure 2 of this Act contains the standard default baseline rules regarding daily life, covering 8 rules. If your complex has never formally filed custom amended rules with CSOS, then these default PCRs automatically apply to your estate. They are your active baseline law. Many schemes believe they have valid custom rules because they passed them at an AGM years ago. But to understand why these house rules fail, you have to look at how the registration laws were completely overhauled. First, consider the pre-2016 rule under the old Deeds Office Registry. Before October 7, 2016, sectional title schemes were governed strictly under the older Sectional Titles Act 95 of 1986. The 1986 Act stated explicitly that no addition, amendment, or substitution of a conduct rule had any force or effect until the body corporate filed it at the local Deeds Registry's office. Many schemes passed house rules at an AGM, put them on a notice board, and started issuing fines. Because they bypassed the deeds office, those rules never technically existed in the eyes of the law. Second, the post-2016 overhaul. When the STSMA came into full effect in October 2016, the deeds office stopped accepting conduct rules entirely. Any new or amended rule must now be submitted directly to CSOS under Section 10, subsection 5 of the Act. This brings us to the ultimate split in sectional title management, the power of enforcement. Many complexes look identical from the outside, but on a legal level, one is completely powerless, while the other holds absolute authority. If a scheme attempts to enforce unfiled deeds office rules or uncertified CSOS rules today, the consequences are severe. First, you face illegal fines. Any financial penalty issued under an invalid, unregistered rule is considered an unlawful charge. The resident can legally demand a full refund or lodge a dispute with CSOS to have those fines immediately expunged from their levy account. Second, you trigger the default fallback. Uncertified custom rules simply vanish and the baseline Annexure 2 prescribed conduct rules take over automatically. So how does a progressive scheme adapt these baseline rules to handle modern lifestyle issues like solar panel installations or short-term holiday rentals safely? Trustees cannot simply invent rules at a meeting. The law enforces a strict compliance pipeline. First, the proposed rule change must be sent out to every single owner with a strict 30 days written notice detailing the exact wording. Next, the body corporate must pass a formal special resolution. This means the change requires a 75% majority vote, calculated in both value and participation quota, of the owners present or represented by proxy at a general meeting or signed off in writing by 75% of all owners in the scheme. Even if the scheme successfully passes that 75% vote, the new rule is still not active law. It must clear 2 final massive validation hurdles. First, under the Act, any custom rule must be reasonable, and it must apply equally to all owners of identical sections. You cannot create special exemptions or privileges for trustees. Second, the rule is completely invalid and legally unenforceable until it has been vetted and approved by the Chief Ombud at CSOS. The Ombud checks the rule to ensure it doesn't violate your constitutional rights or contradict national property laws. Only when CSOS issues an official Section 10 certificate of approval does that custom rule become binding law. The rule is only active from the exact date that certificate is signed. The baseline law is there to protect the community, but a savvy scheme knows how to evolve its rules legally. Trustees, check your files, locate your historic deeds office submissions or your modern CSOS section 10 certificates and stop enforcing uncertified rules. Owners, know the framework before you pay an illegal fine. What is the most ridiculous or illegal rule your complex has ever tried to force on you? Drop your townhouse horror stories in the comments below. Protect your property value, stay compliant, and subscribe to Scheme Savvy, because over the next few weeks we are breaking down each of the 8 baseline rules one by one. Savvy Scout out for now.